company, Fairbridges Wertheim Becker. And we're really pleased to have you here today, Markus Schäfer, who is the Associate Director. Thank you so much for making the time today to present on this topic. Now, before we go live into the presentation from Markus, please note the following. The session is being recorded, and the hot topic that always gets asked, will the information be shared afterwards? Yes. We will share the link to the recording as well as the presentation afterwards. And if you have any questions, please feel free to either put them in the Q&A, the chat box, or raise your virtual hand, either during the session or at the end. And it is also really lovely to see so many of our member companies joined here today, as well as some new companies that I saw on the list. So a big welcome from us at the Chamber here. My name is Nikita Vogel. I am from the Southern African German Chamber of Commerce and Industry, from the Events Marketing and Membership Department. So if you're interested as a member to host a session such as this, please reach out to us. Or if you're not a member yet and interested in the membership, please feel free to connect. I'm always happy to discuss and see how we can collaborate. Without further ado, Markus, the floor is yours.
Thanks, Nikita. I'm just going to share my screen quickly. You can just confirm that you can see that, please.
Yes, I can see your presentation.
Okay. Right. Okay, good morning, everyone, and welcome to the session. So today we're going to be talking about company law, specifically how the new amendments of the Companies Act are being implemented, and a couple of other related issues. So just a brief introduction. My name is Markus Schäfer. I'm Associate Director at Fairbridges Wertheim Becker. A bit of my background is that I come from a German-Irish background. I've been in South Africa for a little while now. I finished school here. I went to the German school in Cape Town before going to Rose University to study and do my law degrees. And then I came back to Cape Town to start my articles at Fairbridges. And yeah, I've been here ever since. So just to give you a bit of an introduction into who we are, who our firm is. So we are the oldest firm in Africa. Fairbridges was actually established in 1812 in Cape Town, and Wertheim Becker in 1904 in Joburg. And then the two firms emerged around 2012 and are together the oldest firm in Africa. Today we're made up of about 30 directors operating across a large array of sectors. So my team is the corporate commercial team. I do also some competition law. And we also have a property law and conveyancing department, labor law department, intellectual property department, insurance, medical malpractice, and deceased estates. And then we also have a fairly large dispute resolution department for those lawyers that like to fight. We like to fight a little less. In the commercial team, we specialize in a range of commercial transactions, acquisitions, mergers, takeovers, kind of restructurings, and then general advice on commercial contracts and also cross-border issues. Fairbridges is a member of Terralex, which is a global network of firms that are committed to cross-border collaboration. So we're one of over 130 member firms across about 120 odd countries, which gives us great access to cross-border issues for all of our clients. And just seeing as we're in a German environment here, just to highlight that our German partners include SKW Schwarz, Rechtsanwälte, Tümmel Schütze and Partners, and Loschet in Cologne, if you are familiar with them potentially. So let's get into it. To give a brief overview of where we are with our company law in South Africa, the primary legislation is the Companies Act of 2008, which actually only came into effect in 2011. And then this, with the common law that's been developed through the courts over time, are kind of the prevailing laws that are important for us today. The 2008 Act was an attempt to modernize and replace the Companies Act of 1973, which in some respects still has sections that are applicable today, but has generally been replaced. And the idea was to introduce a more kind of business-friendly and flexible regime that also align more with kind of global best practices. The oversight and enforcement of the Act is handled by the Companies Intellectual Property Commission and the Companies Tribunal for certain disputes such as company name disputes and kind of similar issues. And then obviously the courts as the overarching enforcer. And what we want to talk about today is the recent changes. There's been an overhaul of the company law regime recently with the introduction of two amendment acts, the Companies Amendment Act 16 of 2024 and the Companies Amendment Act, Second Amendment Act 17 of 2024. Now, the First Amendment Act is not entirely enforced yet. Some sections have become effective from the 27th of December last year. Whilst other sections are not yet in force, we're still waiting for regulations to be finalized, and I anticipate that will happen at some point in this year, but that's remains to be seen. And then the Second Amendment Act is entirely in force. It's a much shorter amendment, but all those sections are in effect already from the 27th of December. And the third thing I want to talk about today is the draft King Code on corporate governance, which was published earlier this year, around in February, I think, for comment, and ties in quite nicely with the amendments that have been made to the Companies Act. So I think they're worth discussing together. And then basically the intention of this presentation is to give an overview of those changes and explain how it will impact our businesses in South Africa, and then discuss any compliance requirements and governance practices that we can or should be implemented as a result of these changes. So I'm just going to talk about the stated aims and objectives of the Act, of the amendments, and then run through some of the provisions that are already in force, and then touch also on some of the provisions that aren't in force yet, but that we anticipate will become law fairly soon. And then I'll move on to the King Code, and then at the end, I think it would be nice to have a discussion on the extent to which issues of corporate governance are being adequately addressed in South Africa, or whether it's a matter of a bit of window dressing and the implementation is still lacking. So I think that could be interesting at the end. And then obviously I'll open the floor to questions if you have any. So the changes that have been proposed or implemented at this point are essentially aimed at enhancing transparency, accountability, and corporate governance, and then also to reduce red tape and make it easier for businesses to conduct their business and to improve investor confidence. Specifically, when the president signed the Companies Amendment bills and made them law, they issued a circular to advise kind of what the main intentions were. And in that circular, they give the following overview. So number one is to promote the ease of doing business and impose greater corporate transparency on the earnings gap between the highest and lowest paid persons in a company. So that's on a remuneration level, and also on a transparency level. And I think, and you'll see, so those provisions aren't in force yet, but we'll discuss them in a bit, and you'll see that that's quite a significant change in how much we know about what's going on in each company. Secondly is to make the conduct of business less burdensome. Third is to tighten the pursuit of delinquent directors or prescribed officers for wrongdoing. And this is a direct result of the state capture inquiry, and the idea that we need to be able to hold directors accountable even after the kind of fairly limited periods for liability that are given in the Act. The The fourth one is to streamline company law to be clear and user-friendly. A bit of a bone to pick with this one because I think the Act is actually quite a piece of work. And, you know, for a layperson or a normal everyday business person, I don't think the Companies Act is very clear or easy to understand at all. It seems that every section you look at seems to refer to 5 other subsections, and then those sections refer to other subsections, and you end up in a bit of a maze. So I think there's a lot of work that can be done into kind of streamlining our company law and to make it more user-friendly. But I think that also goes kind of for law across the board, that we, maybe it's because lawyers are drafting it that we think we need to make sure that we've got jobs in the future to actually understand all of this stuff. And then the next one is to promote the efficient and effective conduct of the domestic economy, as well as attracting foreign investment. I think the less complexity in our law and the less red tape, the easier and the more attractive it is for investors especially foreign investors, to get involved, which I think is a large part of what we want to achieve with our law. And then finally, and very importantly, to prevent unethical, reckless, and criminal conduct in businesses that impact negatively on shareholders, workers, clients, and customers, and the economy as a whole. And I think we're seeing a lot of that in South Africa over the last few years, with some very high-profile companies such as Steinhoff. And I think this is also, and obviously all the companies involved in state capture, I think this is a move towards clearing, to make it easier for us to hold those people accountable. So I'm just going to run through some of the sections now. So Section 40 of the Companies Act deals with the issues of shares for future consideration. So before a company can issue any shares, the board needs to determine the consideration and value of those shares and the terms on which those shares can be issued. And maybe on a clarification point, companies have a number of shares that are authorized for issue, and those are basically shares that can be given to new shareholders. Once those shares are then allocated to a specific shareholder, that's what you call a share issue, and then you have a shareholder that can exercise the rights that are attached to those shares, like voting rights, etc. So the board generally determines the value of the company that the company can receive for its shares, but that value can be realized in cash or other assets. So you have your standard, you pay for your shares. Alternatively, you can have things like share swaps, where you're giving an asset in exchange for your shares. Those are all possible. So the term consideration is given quite a broad meaning in the Act. Importantly for this section, the consideration for shares can also be received in the future, or in terms of an agreement for future services or benefits. So the idea there is that the shares are technically moved into the new shareholders' names, the subscribers' names, but they won't, and their name is inserted into the company's share register, but they will only be given limited access to the rights that are attached to those shares. So the new Companies Amendment Act has clarified this a little bit, because it was a bit confusing as to whether those needed to be held in, or how they were supposed to be held in trust in that instance. But now it's become quite clear that you appoint what is termed a stakeholder, and that is essentially an independent third party, such as an escrow agent or an attorney. And then you have an agreement with the company, and that says to what extent those shares are transferred from the company to the new shareholder, and to what extent that shareholder can exercise the rights attaching to those shares. And unless the stakeholder agreement provides otherwise, the voting rights, appraisal rights, which are rights for minority shareholders, preemptive rights, entitlements to dividends, etc., which are all the rights that attach to ownership of a share, are limited. And they cannot be transferred unless the company has expressly consented to the transfer in advance. So it's a mechanism to provide people with shares where future payment or future consideration is given. Section 45 deals with financial assistance. For this purpose, financial assistance refers to includes the lending of money, but not the lending of money in the ordinary course of a business. So if we're talking about an actual lender, this doesn't apply in that case. But otherwise, it involves lending of money, the guaranteeing of a loan or another obligation, securing a debt, but doesn't include the provision of financial assistance for specific purposes of subscribing for shares. That's dealt with in terms of Section 44 and remains unchanged by these amendments. Section 45 deals with situations where the board can authorize a company to provide direct or indirect financial assistance to a director or a prescribed officer of a company, or related or interrelated company, or to a person related to that director or prescribed officer. So, I mean, a director is obviously someone who is appointed as a director and operationally manages the company. A prescribed officer is a person who is not a director, but is held to a higher standard within the company, and can, for example, be a managing director's wrong term, but chief executive officer or someone like that. So the board can only provide that kind of financial assistance pursuant to a special resolution of the shareholders, which is usually shareholders' resolution of more than 75% approval, and that can be given within the last 2 years. And then the board needs to conduct certain tests. The first one is that it will meet the solvency and liquidity test in the Companies Act immediately after providing the financial assistance, and that test is in Section 4 of the Act. And basically, it's a test to ensure that the assets outweigh the liabilities, and that the company would be able to pay its debts as they become due over the next 12 months. And then they also the board is also required to ensure that the financial assistance that is given in a way that is fair and reasonable to the company, because the board of directors, as a primary obligation, needs to operate in the best interest of the company. And then, where necessary, any conditions included in the company's memorandum of incorporation also need to be complied with. So there's additional requirements that need to be met. Those need to be complied with by the board. Importantly, for the changes that have been made, the requirements that need to be met before a company can give financial assistance do not apply anymore where that financial assistance is given by a holding company to a South African subsidiary. Importantly, it's only to a South African subsidiary. And again, this is a move towards removing some of the red tape that was unnecessary. It's a way of improving kind of cash flow, and should assist businesses in just one less hurdle in moving money and being able to operate efficiently. So Section 48 deals with share buybacks. A share buyback, as it says in the name, is the acquisition of a company of its own shares. And the board of a company can decide to acquire a number of its own shares held by a shareholder, and that can be done for any number of reasons. But essentially, they can never be in a position where they're repurchasing all of the shares, so there's no shares in issue. The significant change here is that the board now requires the approval of shareholders by way of a special resolution, except where the repurchase of shares is done pro rata across all shareholders, or is undertaken by a listed company on a stock exchange. Previously, this section was quite complicated and kind of unnecessarily burdensome, where they had this fairly arbitrary threshold of 5%, where if a company decides to repurchase more than 5% of a certain class of its shares, whether in a single transaction or a series of transactions, that would then become subject to the requirements of Section 114 and 115, which are fairly onerous sections in the Act, dealing with schemes of arrangement and fundamental transactions, and are generally designed to ensure that much larger transactions are done properly and are regulated by the takeover regulations and the panel. This was obviously for the purchase of let's say repurchase of 10% of your shares in a private company was a very onerous set of requirements to meet, and essentially what it meant is also that you had to go get an independent expert to provide a report. So obviously there's a cost involved in that, and it's becomes a very kind of timeless exercise for something that should be fairly simple and should be a tool that a company can use fairly easily. So so this was a change that was made in the new Amendment Act, and it means that essentially a repurchase of shares will not be considered a scheme of arrangement. It will not trigger any appraisal rights, which are the minority shareholder rights, and will not require an expert report. Just to be clear on appraisal rights, because I've used the term a couple of times, in situations where a minority shareholder, so there are certain protections in the Act for minority shareholders, because obviously you don't want to be in a position as a minority shareholder where the majority shareholders can basically dictate everything without you being able to do anything about it. So you make certain provisions for that in your shareholders agreement in order to protect yourself as a minority shareholder. But also you have this appraisal right in the Companies Act in section 164, which essentially puts you in a position where if as a minority shareholder you've taken an opposite position to a specific transaction or a scheme of arrangement, such as a restructuring, and you voted against it, and yet it has still gone ahead, you can then require the other shareholders to purchase your shares and force an exit at market value. So, which is quite a significant mechanism to use as a minority shareholder, and was always disproportionate with something such as repurchasing a small number of the company shares. So I think we moved in the right direction with this one. So Section 72 deals with the Social and Ethics Committee. So a board of a company is entitled to create essentially board committees where certain members of the board are members of that committee, and can become more focused on issues to do with what that committee has been kind of delegated with. So there's certain board functions that are delegated to these different committees, and those committees have the ability to then exercise certain authorities that have been given to it, including making recommendations to the board and even making certain decisions. So in this case, the Social and Ethics Committee is quite an important one. It's not a requirement for every company in South Africa, but it is a requirement for state-owned companies, for public companies, and for other companies that have a public interest score of above a certain threshold. And a public interest score is essentially a score in the Act that's calculated by seeing how many employees the company has, how many liabilities the company has, and how many shareholders the company has, and a few other things. So because obviously where there's a large involvement like that, there is much more public consideration that needs to be taken into play. With state-owned companies and public companies, that's already happening. With private companies, less so. So where your public interest score is quite high, you then have these requirements that are usually reserved for public companies and state-owned enterprises, then apply to your public company as well. And in this case, the Social and Ethics Committee becomes one of those requirements. So the Social and Ethics Committee's responsibility is to oversee and monitor a company's social, economic, and ethical performance, including its compliance with legal requirements and best practices. And for legal requirements, read the Companies Act and other legislation. And for best practices, we'll get into that with the King Code and general governance issues. So previously, all companies that were required to have social and ethics committee, whether they were those public and social, public and state-owned companies or private companies with a large public interest score, were treated essentially in the same manner, in that the board would appoint the SEC, and the SEC would comprise of at least 3 directors or prescribed officers of the company, and then one of them would have to be a non-executive director who had not been involved in the company's day-to-day operations for the last 3 financial years, to create a sense of independence and some checks and balances. The amendment has now drawn a distinction between the state-owned companies and public companies, and then those other companies that I mentioned that have an SEC requirement due to their public interest score. And essentially, they've increased the burden for the state-owned and public companies, to say that those must comprise of 3 members, the majority of whom must be non-executive directors, and must be appointed by the board and then elected by the shareholders at each annual general meeting, in order to create a level of independence, as I just mentioned, but also a form of stakeholder involvement. And I think, again, this is a move in the right direction for transparency across state-owned enterprises in particular, and public companies, and should give us, if implemented properly, should give us more confidence in those companies that we've been speaking about over the last few years that really have failed to come to the table on this kind of thing. I mean, there's a lot of state-owned enterprises, but also public enterprises, as I mentioned Steinhoff earlier. I think this could make a big difference. Another very significant one, which I find quite interesting, is in Section 77. There's a personal liability created for directors of a company. And why this is interesting is because companies are considered a separate legal person from the individuals that either own it or run it, so your shareholders or your directors. And that's different from if I'm acting as a sole proprietor, for example, where I am the company, for lack of a better term, and the liability sits with me. When you have a company and directors and shareholders, the company holds the liability, so they enter into the contracts. And if there's claims against the company, then those claims are against the company itself and not against the people involved in the company. The people are considered simply agents of that company. And that's a level of protection given to individuals that do business in a company. But that's limited to the extent where if the directors breach their duties towards the company and do not act in the best interest of the company, or act negligently or fraudulently or any other kind of misconduct, the company that can then recover any loss or damage that it suffers as a result from that director. And that's where this Section 77 comes in. So the company is entitled to recover losses in the following circumstances. I've just mentioned a few. It's not necessarily a closed list, but I think it deals with the most kind of important and most common ones. So there's the common law breach for fiduciary duty. A fiduciary duty is the duty that a director has towards the company to act in the best interest of the company and to act to a certain standard as well. And then also the common law relating to delict for a breach of the duty to act with a required degree of care, skill, and diligence, or any other provision of the Companies Act not specifically referred to in this Section 77. So those are kind of general catch-alls. And then specifically where directors acted in the name of the company in the knowledge that they didn't have the requisite authority to do so. So they basically acted outside of their scope of authority, and essentially made a deal with a third party that they weren't entitled to make. And then when the company refuses to uphold their end of the bargain, the third party has a claim against them, potentially sues them, potentially successfully. The company can then turn around and hold that director liable for operating outside of what they were entitled to do. Importantly, the liability also exists where the director has carried on business of the company knowing that that business was being conducted recklessly or fraudulently. Again, we think Steinhoff is probably a big one here. Then where the director is a party to an act or omission by the company, despite knowing that act or omission was calculated to defraud a creditor, employee, or shareholder of the company. And or had another fraudulent purpose. And I think what's important there is that it's an act or an omission. And that's where you can see that there's a quite a high standard being placed on directors to also act properly. It's not just to refrain from doing certain things, it's also to make sure that you are doing certain things that you're required to do in the best interest of the company. And then there's also a liability where the director allowed the publication of any materially false or misleading financial statements, or where they failed to vote against the issue of unauthorized shares despite knowing that they were unauthorized. So what we were speaking about earlier, where you have a selection of authorized shares that can validly be issued to people, and then if you have 1,000 shares that have been authorized and 1,000 have already been issued to people, and then the director fails to prevent further issue, therefore creating a liability to the company for those invalidly issued shares. And then that shareholder would obviously have a claim against the company. And what's very important here is that there used to be a prescription period, well, there still is a prescription period of 3 years, which applies to this section, but that can now be extended by a court on good cause shown. So a prescription period is a period where you have a claim that exists, and if you don't act on that claim within a period of 3 years, the claim essentially prescribes, and you're entitled to pursue it, but there's a defense to say that you essentially let your claim lapse. And that's what that prescription period is. So in this instance, the prescription period of 3 years is still there, but you can now apply to a court to have that period extended, where you have good cause shown. And I think where this is interesting is because obviously where you have investigations that are being conducted into these large companies and the conduct of the directors, especially those involved potentially in, say, capture, those reports only come out much later. So you don't actually know the extent of the liability of those directors or their conduct until much later. And you now have the opportunity to approach a court and basically get leave to pursue that liability as a company. And then there was another prescription period of 2 years, which applied to delinquency or probation applications in terms of Section 162. That's now been extended to 5 years and can also be extended further by a court on good cause shown. So delinquency and probation applications are applications that are made to a court to declare a director either delinquent or be on probation for a breach of their duties towards the company. And if an order of delinquency is given, depending on the cause of action, that director can be declared delinquent for life or for a certain amount of years. I think it's 7 years in the Act. And the court is also entitled to make other orders. But what's very important about that, and why it's quite a useful tool, is that if a company or if somebody wants to declare a director delinquent and is successful, then not just declare delinquent for that one company where the misconduct was proven, they declare delinquent across any company that they're a director, and they can't hold that position anymore. So, and very interestingly, these amendments will be retrospective. So they're not just going to be from December onwards, they will apply going back in time as well. So sections that are not yet enforced. Sorry, was that I think I just saw a hand. Don't know if that was. Anyone has a question?
Yes, thank you for the opportunity. Andre de Villiers here from the Chamber of Commerce. I see section 77 does not specifically mention what happens if a director resigns purposefully to basically jump the gun. It doesn't mention it specifically on a past director or whatever the legal jargon is. Can you explain that maybe for me, please?
Yeah, no problem. So interestingly, you are responsible for everything that happens during your term in office. So even if you resign and run away, you are still held liable for that which happened while you had those responsibilities. So yeah, if you conducted yourself or misconducted yourself while you were a director and breached those duties, that company will still have a claim against you, even if that only arises, you know, a couple of years after you've resigned. Okay. So now just to briefly cover the sections that are not yet in force. And these are some fairly interesting ones. One of them is section 26, which deals with the access to company records. And this again goes to a movement towards kind of increased transparency for companies in South Africa. In general, they provide public access to annual financial statements for certain companies. Again, those state-owned enterprises, the public companies, and those private companies that have a high public interest score, and certain other company records as well. So you know, this is again with a shift towards larger transparency in South Africa as to what happens inside companies, and is kind of hand in hand with the new beneficial ownership requirements that exist now, where essentially companies are required to inform the CIPC who the shareholders are and who the ultimate beneficial owners are that benefit from that company, which has been a shift from the past, where the CIPC were essentially only interested in who the directors were and who the people were that were running the company, but weren't genuinely interested in who held ownership in that company. Now, not only do they want to know who owns the company, but they want to know who ultimately, further up the line, with holding companies, etc., actually exercises control, and who ultimately benefits from that company. The new section 30A and 30B deals with remuneration reports, and this is quite a significant change for public and state-owned companies that will be required to publish remuneration policies and reports for their shareholders, and those shareholders will then need to approve those reports. And they have a two-strike mechanism in place, where if you go and you provide a remuneration policy and remuneration report to the shareholders and it's struck down, and then you basically go back, you improve it based on the feedback you've gotten from your shareholders, and you bring it to the shareholders again, and it again fails to be approved, then that has ramifications for those who are in those committees that are providing the remuneration for approval of those policies. But what's quite interesting is that there is a requirement in section 30B for what needs to be included in the policies and the reports. And one of the major ones that's getting a lot of discussion is that you need to give certain pay gap disclosures. So you need to say in these reports now, what's the difference between the person that earns the most in this company and the person that earns the least in this company? And again, that's a matter of transparency, but it's also, I think, a move towards highlighting the inequity potentially that happens in these companies, and particularly on the top level, you know, how much people earn, and how much people get access to, and it's not just on a salary level; it's benefits, options, it's everything. So I think this is quite an interesting change. It's probably going to face, it's going to require some new regulations to be issued, which is, I think, why it hasn't been affected yet by the president. But I think that's quite an interesting development. So the third one there is section 38A, which introduces the concept of a validation application. And this is quite an interesting practical measure that's been introduced into the Companies Act, where if there's an issue with the issue of shares, where they haven't been properly issued, or they've been issued above and beyond the shares that are entitled to be authorized. There's now a mechanism to apply to a court to basically have that situation regularized. And why that's I think quite good is because previously there was not much in the way of remedies here. You basically had to ratify a situation where shares were issued in excess of the authorized share capital, but that had to be done within 60 business days. And if that wasn't done, and that ratification was done by shareholders, if that ratification wasn't done, the share issue is a complete nullity, and the value received by the company plus interest at the prescribed rate of interest has to be returned to the subscriber. And that's why you have that that situation where that becomes a director's liability if they don't prevent the issue above the authorized share capital, because it actually has quite serious consequences. And you know, it's one of the situations where if you only realize that that's the case much further down the line, and you've implemented decisions based on votes that those shareholders have cast, you know, unraveling that is a nightmare. So it's good that we now have a mechanism in place where you know, if mistakes were made, and generally there's good faith, you can apply to a court to kind of regularize that situation. And hopefully, you know, it should be interesting to see how these applications go. It's a bit unclear at the moment what you need to exactly prove and what the requirements are, but I think it's an interesting move in the right direction to not create unnecessary liability where there really shouldn't be any in certain instances. And then the final one, just to mention quickly, is Section 118, which deals with regulated companies. And regulated companies, the current definition for regulated companies continues to apply, which it's important because regulated companies attract the application of the takeover regulations, and then which is obviously a bit more of an onerous issue. And a private company is only a regulated company at the moment if more than 10% of its shares have been transferred within the previous 24 months, other than between related persons, or if the MOI says the takeover regulations should apply. But again, that opens itself to a situation a little bit like with the share buybacks, where you have a very simple situation. There's simply been a share transfer in the last 24 months, but it's not an overly complex or overly public, you know, a matter of public importance or anything like that, or a matter of you know, competition law or anything. And but yes, you would still be tied into these takeover regulations. So I think this is a sensible change. The amendment now provides that a private company will only be a regulated company if it has 10 or more shareholders with a direct or indirect shareholding in the company. And then there's going to be financial thresholds for annual turnover or asset value that are going to be introduced by the minister as well, which I think will catch in the net the companies that are actually wanting to regulate, and not simply any company that has had a share transfer in the last 24 months of over a certain amount of shares. So now I want to move on to the draft King Code on corporate governance. So this is King 5. And the King Code is essentially a set of guiding principles on South African corporate governance. It's compiled by a group of people that are called the King Committee. And they basically are involved in the drafting process. They approve the publication, and they work together with the Institute of Directors in South Africa to publish this document. And essentially what they do is they put together a set of best practices for organizations to achieve good governance, ethical leadership, decision-making, and achieving sustainable economic, social, and environmental performance. So those are your ESGs. Essentially, they see it as a critical tool for strengthening public and private institutions to the benefit of the entire economy. And this new draft is designed to present an updated, relevant, and effective guiding standard. It's the fifth iteration. There's been 4 iterations prior to this, and the first one being in 1994. And this new King Code was published for comment on the 24th of Feb 2025. And the opportunity for comments lapsed earlier this month. So we should hopefully have, at some point in the near future, a new King Code, which is supposed to give us a clear idea of what good governance will look like in South Africa. So the chair of the King Committee says that King 5 considers both local and global developments since King 4 was launched in 2016 and incorporates critical shifts such as the recent amendments to the Companies Act, involving practices in remuneration governance, global developments and sustainability reporting, and the rapidly advancing technological landscape. So I think that's quite interesting, simply because, we'll talk about it now, but it's clear that the corporate governance side of things and the legislative side of things are moving in the same direction, and that the amendments to the Companies Act that have now been implemented could well be, at least in part, a product of previous King Codes that have been drafted, and that we're moving hopefully towards kind of a more just corporate environment. And why that's important is that the King Code in and of itself is not actually law. It doesn't carry sanctions the way the Companies Act carries sanctions, but it is kind of just a guiding document that sets out policies and practices to achieve a higher standard of governance. You have essentially a disclosure document that you prepare, and you say what you're going to apply within your organization, and you state why that's going to help you achieve kind of better governance, achieve more ethical leadership, better decision making, more transparent decision making, perhaps, and generally create a more sustainable economic, social, and environmental environment. And then essentially, and that is the only requirement that you basically have to apply and explain. And the idea is that you are actually showing your stakeholders why you're doing what you're doing, and that it's not simply like a tick box exercise that you blindly follow the rules, which can often be the case in when certain laws are implemented, that essentially organizations do what they need to do to kind of get what they need to get, and they don't actually apply themselves with the ideas behind the legislation. So I mean, it's a controversial piece of legislation, but the BE Act is often like that, where people make sure that they're complying with the BE Act, but there's a lot of kind of smoke and mirrors. So yeah, as I mentioned, as company law develops, the principles enshrined in the King Code are being adopted into legislation and are incorporated into court judgments. So that becomes our common law then. So when there's a law that needs to be informed by, and it's up for debate, the courts will look at everything that informs that law. And now the King Code and these corporate governance policies are kind of becoming more prevalent, and will therefore inform a lot of the arguments made to a court, and maybe even the decisions that the courts have made. And once they make a decision, it's binding, and it becomes part of our law on a high court and Supreme Court level anyway. And I think that's quite interesting, and that's how the King Code moves from governance policy to actual binding law. So maybe it makes sense to just run over quickly what corporate governance even means, because this term is thrown around quite a bit, and it's filled with buzzwords and is often not kind of broken down. And even when they break it down, it still seems to be filled with buzzwords. But how the King 5 draft has set it out, they say that the corporate governance is the exercise of ethical and effective leadership by the governing body towards the achievement of the following governance outcomes for the organization. And they break that down to 4, being the ethical culture, which is a value and belief system, and the practices that are informed by that value and belief system within the organization that is supposed to promote ethical behavior and decision making. The performance, which is that the organization is actually creating value within its economic, social, and environmental context in a sustainable manner. Conformance, which is the effectiveness, consistency, and discipline with respect to how that organization complies with laws, regulations, and adopted standards, and then obviously their own internal controls. And then legitimacy, which is, the organization has a good reputation and is well trusted and has strong stakeholder relationships. And then how they break it down is that ethical leadership is exemplified by the governing body cultivating the characteristics of things like integrity, competence, responsibility, accountability, fairness, and transparency. But effective leadership is results orientated and entails a governing body directing the organization's performance and value creation in its economic, social, and environmental context. And I think that's quite important, because we often, when we talk about corporate governance, we get into this space sometimes where we talk about ethics and values and all of this kind of thing. But at the end of the day, whilst that's all well and good, there's a business to be run, and there's a financial implication to that business. And when you have all of these non-financial elements that are required to be incorporated into how you operate that business, it can be quite difficult. So where stakeholders, have started creating financial incentives for good governance, such as, you see it with anti-bribery requirements, but on a new level, ESG requirements, where investors will come and they'll hold it to a standard, and that becomes a financial incentive, which I think is quite an interesting direction for us to move in, because that's when it becomes real. Otherwise, it's a bit of a kind of wishy-washy value system that is never actually applied, and there's no sanction to not actually implementing it, whether it's an external or internal policy. So I think the focus on creating value and high performance within an organization is important in this environment. So the fundamental concepts and philosophies are integrated thinking amongst different parts of the company or organization. They've introduced Ubuntu into the King 5 now, discussing corporate citizenship and stakeholder inclusivity. And then, as I mentioned, a lot of movement towards sustainable development, and that's your kind of ESG goals. So the practices that must be adopted to implement these principles. And here we're looking at the governing body, because they're essentially the ones that determine best practices and how they are to be implemented. Therefore, responsibilities are to steer the organization from a strategic perspective, to approve policy and planning to give effect to that direction. So you have a broader strategy, and then what are the policies that you actually implement to ensure that broader strategy can be given effect to on a day-to-day basis, and then an overseeing and monitoring role to ensure that the policies that have been implemented are actually being complied with and are having the intended effect. And then finally, to ensure accountability for that organizational performance. So reporting and disclosure by the organization to the governing body, but also by the governing body to stakeholders. And that, again, is a higher level of transparency, a higher level of accountability that holds you to the standard that you've set for yourself. And I think that's the key. So I'm just going to run through the general principles that have been set out in the King Code, and then and they set out in the King Code, they set out a list of different things to think about and different practices that can be implemented to align with these principles. But I think honestly, this is a matter that is quite subjective to each organization. So the organization needs to decide where they stand and what they want to achieve from a corporate governance perspective. Obviously, you need to comply with the law, but beyond that, where do you stand? What are the standards you're setting for yourself, as opposed to the standards that are being set externally? And the governing body are the people that need to decide how that's done. So from a practices to be adopted perspective, I think that needs to come from the organization itself, because also every organization operates in a different industry, operates in a different culture. Certain things can be done for a small organization that can't be done for a big organization, and vice versa. So I think all of these things are fairly subjective, but I wanted to raise them because a lot of people on this call from different organizations, different businesses, and it could be kind of good food for thought as to what's happening in your business and how what you want to implement in your business to give effect to these good governance principles that have been introduced by the King Code. So the first one is leading ethically and effectively as the focal point of corporate governance in the organization. So that's what we spoke about from a strategic perspective. You know, what is the direction that you want to move in as a starting point? The second one is the ethics organization and how the governing body governs that in a way that fosters an ethical organizational culture and promotes responsible corporate citizenship. And I think that's an internal accountability system and a policy thing. So how does the governing body dictate that the strategy should be implemented, and how do they ensure that it actually is implemented and people that are responsible for that are held accountable to it? The governing body should ensure that the organization's purpose, business model, and strategy result in a sustainable value creation within its economic, social, and environmental context. And again, that's within that organization's context, which can be a very different thing depending on which industry you work in or what you do. So again, to ensure that reports are issued by the organization to enable stakeholders to make informed and holistic assessments of how the organization creates sustainable value within its economic, social, and environmental context. And that's these disclosure forms, disclosure templates that the King Committee created, which should make it easy for governing bodies to implement the apply and explain practices. So that stakeholders know exactly how what they're trying to achieve, how they're going to do it, and why they're doing it that way. Then the next one is that the composition of the governing body itself, that there's a different mix of competencies, diversity, a level of independence, and to ensure that the roles are performed objectively and effectively. And then arrangements for delegation to its committees and individuals, so delegation of authority, policies, how can the objectives be effectively discharged, and how does the delegation operate, ensure operational effectiveness and clarity on authority and responsibilities. So do people actually know what they're supposed to be doing? Do we know who to go to in certain issues? Who's responsible for what? And I think that in particular for larger organizations is quite important, because what it also does is it gives people the clarity that they are the ones that are the decision makers, and that the buck doesn't need to be passed to somebody more senior. The more decisions that are made effectively and properly on a kind of more junior levels, the more effective a company often operates. And then the governing body should also govern risk and compliance to enable the organization to expand its opportunities and to achieve the strategic objectives that it's set. And then obviously as we move forward, use of information, use of technology is always going to be an important thing. AI is obviously the discussion at the moment. How does the governing body implement those things for better opportunities for achieving its strategic objectives? And then, so the next one is a remuneration matter, which is quite interesting, because this is one of those that has now become something that will become law in terms of the Companies Act as well. So that's a good example of a crossover between what the King Committee have determined is good governance and what has actually now become something that is a requirement in terms of the Companies Act. So fair remuneration, transparency about the value creation and who is remunerated, how, and what's fair in the context. And the final two that they give is to ensure that assurance services and functions enable an effective control environment and safeguard the integrity of information used for decision making and disclosure by the organization. So obviously to ensure that the data that is relied on is actually reliable. And then that's a responsibility that kind of comes from the top down, even if it's functions that are performed on a lower level. The effective control of that still needs to come from the top. And then finally, that they act in the best interest of the organization over time, adopt a stakeholder inclusive approach which takes into account material stakeholders' interests. And I think that's kind of a catch-all for a more holistic approach to how companies operate now, how corporate governance should work, as opposed to just looking at shareholder value, for example. There's more people involved in the company than just that. So that brings me to the end of the King Code, and I just wanted to raise a discussion point. We're looking at the new amendments to the Companies Act, what they're looking to achieve, and then we have simultaneously this new King Code, which is not binding, but it is a policy document that can be used by various stakeholders to hold companies responsible and hold them to a higher standard, and for companies to hold themselves to a higher standard. And I'll just be interested to know, from those on the call who are, running their own businesses, do you see these changes as something that is truly improving corporate governance in South Africa and setting higher standards for the conduct of companies and individuals within that corporate environment? Or do you see it as a bit of a political cover designed to create the appearance of progress without necessarily driving meaningful change beyond a superficial tick box exercise? And I guess in particular with the King Code, is that something that's that is too easily dismissed? Is the Companies Act clear enough on the change that it's made? It's interested to see how that works in a practical space. And then obviously, if there's any questions, I'll be happy to take them.
Thank you, Marcus, and thank you for posing this question. I think this will be an interesting discussion round. So if we can get, please, your input on this practical discussion point.
I mean, the reason I asked this question is because when I read the King Code, for me, it reads slightly like it's a very idealistic document. But, as a lawyer, you want to see how you can actually hold people to it. And I think there's no way of doing that at the moment. And I think until, the Companies Act really catches up, that's not going to happen. Yeah, I think there's a hand. Yaku?
Just very quickly from my side.
Yaku, we can't hear you.
Let me just try and see if I can get a...
It sounds like you're very far from the speaker.
Is that working better?
Much better, thank you.
Great. I think there's two views, almost three views to the whole thing. I think when you within a public company, state-owned enterprise, or any one of those companies, these things for you should be extremely important and should be things that you go around with, especially the King, now King 5 principles, in order for you to be able to try and indicate that you will at least move in the direction of showing that you do really take this seriously and that you work in the best interest of the company and the public in that space. When you have, let's say, more than one private shareholder, and it's a large private company, but with multiple shareholders, I think you will find that some of these things it gets just put to the side. It's a little bit difficult to get to all of them. However, for me myself, it's still something that I think is important enough to go through and see what is applicable, what is good practice, what is things that you can add in order not to fall foul later on as a director. So within that space, specifically as a director, the King 5 or previously King 4 was a good guideline to be able to assist you with a lot of things that you are able to at least attempt and at least partake in. It might not be fully compliant. That gives you also a much better foot or a much better entry into the Companies Act and what the requirements is there. If you are able to also look at some of those. When you run your own company and it's small and you have limited shareholders, then you need to at least just make sure that you tick some of the boxes within the Companies Act, because not too many shareholders are going to frown upon you or look to get to you, because at the end of the day you become liable yourself. So I think that's the three scenarios in the various companies that I've worked with, where that there's more emphasis as you go through the models.
Yeah, I think that's quite an interesting point, because as we see, whilst King Code, a lot of the policies aren't necessarily implemented into the law now, we can see that the Companies Act has to some degree involved or introduced certain things that were in King 4 or are now kind of reinforced in King 5. So I think it's a good point to not ignore it, because you can set yourself up quite well for compliance down the line. If you look at what kind of the direction that we're moving in, maybe. I think that's a good point.
Marcus, we also have a question in the chat box asking how will these changes be policed, and which of these acts and amendments are applicable to German companies doing business in SA?
So how it will be policed, the Companies Act is a law, so it's policed by different stakeholders that can have different claims depending on the level of misconduct. Often, like what we spoke about, the directors are held responsible by the company, and third parties can hold the company responsible. So that's how it's policed. You also have complaints that can be made to the company's tribunal, for example, where or even the takeover regulation panel, where certain companies are involved, and so it's policed in kind of a number of different ways. The King Code is not really policed because it's not law, so that's where we're saying that there's very limited sanction, and that sanction is almost a kind of a soft sanction that the stakeholders that have power, even in terms of investment ability or something else that you're looking for, or if your partners hold you accountable, then that's kind of like a soft standard that can be a form of policing, I suppose. But there's no active sanction there. Your second question was how it involves German companies operating in South Africa, was it?
Yes. Well, which of these acts and amendments are applicable to German companies?
So, I mean, they're only applicable to German companies to the extent that those German companies have a base in South Africa. And if they do have a base in South Africa, then they are absolutely held to the standard. So the Companies Amendments Acts will apply, and to the extent that those companies are deemed to be conducting themselves with good governance, the King Code will apply to them as well. But those changes that are mentioned in the Companies Amendment Act and the existing Companies Act and the future proposed amendments that will become law soon will all apply to the South African branches of those German companies, for sure.
Thank you so much. Let's see, do we have, yes, we've got Alex, yes, go ahead. Would you like to add on to your question?
Yes, hi, sorry. Thanks for answering that. That was great. I've got a question about the remuneration, because obviously we've got the Poppy Act, and I know in the EU that's going to be a bit of a, revealing information like pay slips and that kind of thing might be tricky. How do you think that that's actually going to go through? those amendments on remuneration particularly? Thanks.
Yes, I do think they'll go through. So this act was a bill for a number of years. There was a lot of discussion on it. They had all the public participation and everything that you're required to have in those stages of developing your legislation. And the president has assented to it. So I absolutely expect this to be implemented. The question is more a matter of when and how. And there's not much clarity on that right now. But as I mentioned, especially with remuneration, that Section 30A and Section 30B, I think there's going to be quite a lot of regulation that will need to be implemented alongside that, just because it is such a sensitive topic. And I think that's probably what they're working on now. So I can imagine that particular section will be maybe kicked down the can. The can will be kicked down the road a little bit, because it's a sensitive issue, and because I think they want to make sure that when it's done right, so there's no challenges like you obviously see with some of the other acts that have come in recently.
Do we have any further questions? You can post them in the chat box or raise your hand and ask the question directly as well.
Yeah, I mean, if there's no further questions, I do have my email address on screen now. So please feel free to email me directly. Sometimes, there's questions you don't want to ask on the call, or you only think of something a little bit later, or once you've maybe had a look at the slides again. So if there is anything, there's my details. Feel free to give me a call as well. I have no problem with that. And other than that, I'd just like to say thanks to everyone on the call for joining, and thanks to Nikita and everyone at the German Chamber for setting this up. And yeah, I think it would be great to do something similar again in the future.
Fantastic. Well, thank you so much, Marcus, for your time on behalf of the Chamber, and to Fairbridges Wertheim Becker for allowing you to take the time to present today. So yes, we will share a follow-up email with the recording as well as the presentation and the details that you see on screen here. If you've got any other related questions, please feel free to reach out to the marketing and membership team. And yeah, have a fantastic day further.
Thank you.
All the best.
Thank you. Bye.
Bye.
Thank you.
Thanks so much.
Bye.
Have a nice day.
Thank you. Bye.